unusual haste, meaning thereby in a matter of hour or so, the whole thing was over. The same amendment was placed before the National Assembly during the night between 20th and 21st October 2024. And was passed, I am allowed to say, in unholy haste during the night. The entire debate, presentation, all that, objections, walkouts, all that took place during the night. Nothing during the day.
मतलब ये इससे मुताल्लिक तो नहीं है अभी
जी सर, मैं सिर्फ इंस्ट्रक्टिव टेक्स्ट दे रहा हूँ.
देखिए ना, जो स्टेप जब आए थे 26 अमेंडमेंट का, उसके ऊपर उन स्टेप पे आपको सुनेंगे. अभी कॉन्स्टिट्यूशनल बेंच पे है. अगर आप इस पे करें तो
उसी पे करो, उसी पे करूँ.
हम इसको इस तरह
लेकिन ये तो एक बेसिक फैक्ट है.
हम इसको इस तरह, हम आपकी बात से इत्तेफाक करते हैं. नो डाउट दिस इज वेरी इंपॉर्टेंट केस. यहाँ से बाकी बातें आप जो मेन केस आएगी उसमें आप बताएं कि किस तरह हुआ, अच्छा हुआ, बुरा हुआ.
मैं उसमें नहीं जा रहा इस वक्त.
दिस इज वेरी इंपॉर्टेंट केस. अब आगे
इस वक्त जो बात मैं करूंगा ये फुल कोर्ट के कॉन्टेक्स्ट पे होगी, मेरिट्स पर नहीं मैंने जाऊंगी. सिर्फ एक फैक्ट बताना था. At that time, meaning thereby 20th or 21st, the total strength of the Supreme Court, this one court was 17, including the Chief Justice of Pakistan. On 20th, 21st of October, there were 17 judges of this honorable court, including the Chief Justice of Pakistan. But on the 25th of October, the Chief Justice at that time retired, and therefore the strength of the judges of the Supreme Court after the 25th of October 2024 was 16 judges. So in this petition, we are seeking the hearing of these petitions by full court, which means the full court in existence at the time of the passing of 26th Amendment, which means, may I submit 17 minus 1, 16 judges. The present bench of 8 learned judges consists of all 8 judges are amongst those 16 judges, because all of your lordships were judges at the time of passing of the 26th Amendment. What we are seeking here is that, including these 8 judges, there are 8 other judges who were judges of this honorable court at the time of passing of the 16th Amendment. So 8 honorable judges are here, and we are seeking from this honorable court for a decision to include the other 8 judges who were judges at that time when the 26th Amendment was passed, and who continue to be on this honorable court at present, meaning thereby they are all available judges. So for all intents and purposes, these 16 judges full court is available as of today, and we are seeking that let this bench be expanded and be turned into a full court of 16 judges. Now, sir, which submissions which I am going to make is all in the context of full court hearing, not in the context of merits, for which we will make submission as soon as that comes. the 26th Amendment, sir? What the 26th Amendment purports to do, it amends the process of appointment of judges to the superior courts.
So एक question meanwhile. Do you agree now this 26th Constitutional Amendment is part of the Constitution?
I don't think so.
No, this is
That's what I'm going to argue.
part of the Constitution or not?
It is not. As per my arguments come, this amendment is against the very basic feature of it.
मेरिट पे तो बाद में बात करेंगे. अच्छा या बुरे पे बाद में बात करेंगे. लीगल और इलीगल पे कॉन्स्टिट्यूशन और अनकॉन्स्टिट्यूशन पे तो बाद में बात करेंगे. As for today, this is a part of Constitution or not?
My humble submission, after your amendment, let me complete. Sorry. After your lordships examine, I'm seeking the larger bench consisting of all 16 judges. If this honorable court comes to the conclusion that it was against the basic features of the Constitution, therefore this would cease to exist from the date it purports to have come into force. This is my submission.
देखिए, दो यहाँ कोई क्वेश्चन जब तक क्लियर नहीं होगा तो फिर वो एक पेज पे नहीं शायद आ सकेंगे. देखिए ना, we are bound by the Constitution.
Valid Constitution.
In our view, वो चले आप उसको राइटर आप लगा लें. As per our view, you are also bound by the Constitution, unless it is declared as such as you pray. उस वक्त तक हम अगर एक बेसिक पॉइंट पे एग्री नहीं करेंगे. अब डेफिनेटली नेक्स्ट क्वेश्चन यही था, ये जो आपने अभी फरमाया है, व्हाट इज द कॉन्स्टिट्यूशनल प्रोविजन. अब अगर आप ये कहें कि 26th अमेंडमेंट को आप नहीं मानते, वी आर बाउंड बाय दैट, हमने उसके मुताबिक चलना है, हम तो नहीं कर सकते अनलेस इट इज डिक्लेयर्ड. अदरवाइज जब डिक्लेरेशन हो जाएगा तो फिर
जी सही है.
इस वक्त आप भी जो आर्गू करेंगे डीमिंग इट की पार्ट ऑफ द कॉन्स्टिट्यूशन, फिर ही हो सकेगा. वरना ज़ाहिर है आप कहेंगे कि हम तो मानते नहीं, बल्कि ये क्या डिक्लेरेशन और क्या फिर वो तो
ये बेंच भी उसी
मेरी गुजारिश यही है.
ये मौजूदा बेंच भी उसी 26th कॉन्स्टिट्यूशन अमेंडमेंट के तहत नहीं है और आप इस बेंच में आए हैं,
उसी पर मैं आऊंगा ना.
उसका मतलब ये कि
और हामिद साहब, अगर ये नहीं है, यू से दैट इट्स नॉट पार्ट ऑफ द कॉन्स्टिट्यूशन, ठीक नहीं है, तो व्हाई देन यू हैव चैलेंज दैट? आप समझते हैं तो इसलिए चैलेंज किया.
Not part of the Constitution if my submissions are accepted by this.
कोई तो वो
Our court not cleared that.
It is the part of it, whether right or wrong,
I'm subject.
but that has not been suspended by this court.
जी जी.
तो
देखिए,
फिलहाल तो है.
आपने जब 26वीं तरमीम की वैलिडिटी के बारे में सुनना है, आपने 1 मिनट के लिए एक दफा फिर 21st of October पे जाना है, क्योंकि at that time it was passed. And in all such cases, whenever a part of the constitution or amendment is struck down, it is struck down from the very date when it was introduced to begin with. So that is what it is. For the time being, all I have to show before this honorable court that what is the effect of this amendment, and being effect of this amendment, does it affect the very basic features of the constitution? Not that
वो मैरिज पे है हामिद साहब. इस वक्त जो है ना वो हम प्रीमेच्योर स्टेज पे जा रहे हैं.
नहीं,
अभी आप सिर्फ जो है ना कॉन्स्टिट्यूशन ऑफ बेंच के ऊपर, इफ यू विल कन्फाइन योर आर्ग्यूमेंट्स फॉर द कॉन्स्टिट्यूटिंग द फुल कोर्ट, दैट वुड बी बेटर, बिकॉज आपकी स्टाइल में हम सुन रहे हैं, वी आर नॉट हियरिंग इन मेन केस टुडे ना. So I hope you
basically
reply to that.
The primary arguments which will be there for your lordships on merit, which I am not going at, but just for the sake of submission that a full court may be constituted, I will only refer to those, not yet saying that how they are against the basic features. I will not argue that now. I'll argue that later. But I'm just showing that one of the basic features of the Constitution is the independence of judiciary. And what I'm trying to submit here, by amending Article 175A, the independence of the judiciary has been adverse. adversely affected. So that's only to this extent I'm making. The other is that the separation of powers have been affected because under Article 191A, which is the product of the 26th Amendment, now appointment of judges or formation of benches, which was always the function of internal function of the Supreme Court. The Chief Justice, or later when that law was brought in, which made the committee of Chief Justice and two senior most judges, it was the function of internal function of the Supreme Court. For the first time in the history of Pakistan, a mechanism has been introduced through Article 191A by which the formation of benches have been taken away from the Chief Justice or for that matter.
सारी बात देखिए फिर मैरिट्स पर जा
नहीं, मैरिट्स पे नहीं जा रहा।
चलिए एक क्वेश्चन करते हैं,
एक्चुअली बात कर रहा हूँ ना।
एक क्वेश्चन करते हैं।
ठीक।
अब आपकी प्रेयर अटेंड करने के लिए under the provisions of this constitution, including 26th Amendment, whether this case can be fixed before the 16-member bench as your prayer is, वो हमें constitution से बता दें, ये होगी direct आपकी।
जी, I'll show how this had to be done by the 16-member bench, or I would say before a full court of 16 judges in existence at the time of passing of the amendment.
अब दो कमिटीज हैं, उन्होंने प्रिरोगेटिव है उनका ऑटोमेटिक ट्रांसफर बिफोर द कॉन्स्टिट्यूशन बेंच। अब फिक्सेशन दोनों कमिटीज का प्रिरोगेटिव है, तो उस कमेटी में जाना वो समझाते हैं कैसे हम यहाँ से ज्यादा से ज्यादा एट द मोस्ट वी कैन रेफर टू द कमेटी।
इसमें जो बात मैं अर्ज कर रहा हूँ वो ये है कि पहली दफा, that's why I'm pointing out 191A. I'm not reading the whole article. Shall read that. इसमें एक mechanism दिया गया है forming a certain judicial commission which are going to fix the cases before a constitutional bench. The first time a concept of constitutional benches within the Supreme Court. Otherwise, Supreme Court is a constitutional court. Every bench is a constitutional bench.
वो कमीशन जो है ना, वो फिक्सेशन ऑफ केसेस के लिए नहीं है, वो अपॉइंटमेंट फॉर द कॉन्स्टिट्यूशनल बेंच है।
वो रिलेवेंट फॉर वो जो प्रोविजन पढ़ ले तो बेहतर होगा।
जी,
वो रिलेवेंट फॉर लेकिन जो प्रोविजन है रिलेवेंट वो पढ़ ले।
केसेस जो है अंडर द कॉन्स्टिट्यूशन वो
the appointment, the nomination of constitutional bench is vested in the jurisdiction of the Judicial Commission. But so far as the cases are concerned, in section Article 191A, there is a committee constituted itself in the article for deciding the fixation of cases.
And constitution of benches as well.
It's just like a committee constituted under Practice and Procedure Act for the normal benches.
Now, sir, there shall be a constitutional bench. There shall be constitutional benches of the Supreme Court comprising such judges of the Supreme Court and for such term as may be nominated and determined by the Judicial Commission of Pakistan from time to time. Now, sir, there is a Judicial Commission which is under Article 175A. Now, there is another Judicial Commission which consists of, provided that the constitutional benches may comprise equal number of judges from each province. Yes, sir. The most senior judge amongst judges nominated under Clause 1 shall be the most senior judge of the constitutional benches. No bench of the Supreme Court other than constitutional bench shall exercise following jurisdiction vested in the Supreme Court, namely original jurisdiction of the Supreme Court under Article 184, appellate jurisdiction of the Supreme Court under Clause 3 of Article 185, where a judgment or order of a High Court involves constitutionality of any law or a substantial question of law as the interpretation of the Constitution, advisory jurisdiction of the Supreme Court under Article 186. For the purposes of Clause 3, a bench consisting of not less than 5 judges to be nominated by a committee consisting of the most senior judge of the constitutional benches and next two senior judges from the judges nominated under Clause 1 all petitions and appeals. Now, sir, this has to be read with Article 175A, because now the Judicial Commission, earlier the Judicial Commission was did not consist of any person who is outside judiciary. The point I am trying to make here, that prior to 26th Amendment, the Judicial Commission was already there under the 18th Amendment. The difference that has come about is that Judicial Commission, formation Judicial Commission, or it had a majority of judges on that. It had majority of the judges in that Judicial Commission. Whereas after the amendment, now the judges are in a minority. Now, Chief Justice, three most senior judge of the constitutional benches, then Federal Minister of Law and Justice, Attorney General, an advocate having not less than 15 years practice in the Supreme Court, Pakistan Bar Council, 2 members from the Senate and 2 members from the National Assembly, of whom shall be from the Treasury benches, 1 from each bench, each house, and 2 from the opposition benches, 1 from each house. The nomination from the Treasury benches shall be made by the leader of the House and from the opposition by the leader opposition, meaning thereby they are members, have to be from the Parliament. Provided that during the time when the National Assembly stands as all the remaining 2 members, not a point. A woman or a Muslim, non-Muslim, other than member of Magistrate Shura Parliament, who is qualified to be a member of the Senate as a technocrat, to be nominated by the Speaker of the National Assembly for a term of 2 years. So, sir, in a nutshell, what it says, we will go more in detail in this when we argue about merits. But for the sake of why were you asking for full court, I have to show that there has been a transformation by the 26th Amendment. Prior to that, the Judicial Commission consists of a majority of judges of whether High Court, Supreme Court.
तो फिर वो उसकी merits की बात हो जाएगी ना, फिर वो कमेटी अलग थी, उस वक्त पार्लियामेंट्री कमेटी, स्टेट मेंबर्स।
मैं सिर्फ ये कहना चाहता हूँ कि ट्रांसफॉर्मेशन जो हुई है उसमें majority of judges have gone into minority, and the majority is now with the executive branch.
ये तो आप फैक्ट्स बता रहे हैं, आप हमें वो कानून या आइन का वो प्रोविजन बताते हैं कि जिसके तहत हमारे इख्तियार हो कोई बेंच बनाना या ताकि उसको आगे लेके चले, कानून के तहत हम करेंगे, आप वो बताएं।
ये मैं सिर्फ फर्ज कर रहा हूँ इस हद तक कि इससे इफेक्ट होता है इंडिपेंडेंस ऑफ जुडिशरी के लिए।
तो मेरिट पे आपका अच्छा केस होगा, मेरिट से अच्छा केस होगा, वो मेरिट पे देखेंगे। आज
अभी
इस बेंच बनाने के लिए आपने हमें वो रिलेवेंट प्रोविजन ऑफ द कॉन्स्टिट्यूशन या लॉ बताना होगा कि पहले हमें पता तो चले कि हमारे इख्तियार किस कानून के तहत है बेंच बनाने का, फिर उसमें ये रीजन देखेंगे फॉर दिस रीजन वी आर इंक्लाइंड टू कॉन्स्टिट्यूट द बेंच और वी आर नॉट इंक्लाइंड टू कॉन्स्टिट्यूट। पहले आप गाइड अस टुवर्ड्स द रिलेवेंट प्रोविजन, उस पे आगे आगे बढ़ो।
रेलेवेंट प्रोविजन 175A है जिसमें के कॉन्स्टिट्यूशनल बेंच है, जिसमें के जो जुडिशियल कमीशन है उसकी फॉर्मेशन बदली गई है। उस फॉर्मेशन का क्या इफेक्ट है, मैं अभी डीपली इनटू दिस क्वेश्चन नहीं
बदली गई है या पार्लियामेंट्री कमेटी को मर्ज कर दिया उसके साथ, ये इशू आया है ना।
वो कब किया?
बस पार्लियामेंट्री कमेटी को मर्ज कर दिया जुडिशियल कमेटी। पहले पार्लियामेंट्री कमेटी अलग होती थी, नाउ इट हैज बीन मर्ज इनटू 175A। दिस इज द रीजन ऑन दिस
ह्यूज ट्रांसफॉर्मेशन। व्हाट आई एम सेइंग,
देखिए ना, इस वक्त हम आपकी सारी बातों से भी एग्री कर जाए ना, हाउ वी कैन, देखिए ना, मैंने पहले भी कहा वी आर बाउंड बाय द कॉन्स्टिट्यूशन,
दैट्स वेयर वी कम।
इट इज टुडे इन द बुक। इसको मानते हुए हमने वोट भी यही लिया है, इसको मानते हुए हम बेंच पे बैठेंगे। इस कॉन्स्टिट्यूशन के तहत जो आपकी प्रेयर है 16 जजेस बेंच बना, वो हमें बता दें।
उसी पर उसको यहाँ सिर्फ बात जो मैं कह रहा हूँ वो इतनी है कि इस अमेंडमेंट के तहत जो जुडिशियल कमीशन था, which was actually had a majority of judges have been transformed into an judicial commission where judges are in a minority. And therefore, we have to see it in the context of independence of judiciary and separation of powers.
Why it was done?
ये
देखिए आपको पास के अंदर जाना होगा. There was a case of Mahmood Bhatti, Munir Bhatti, wherein the role of Parliament committee was subsided. There were so many issues and so many arguments and objections on that it's only a stamp fixing authority. They have no role to play. They can't say anything because always the judgment of Supreme Court supersedes them.
absolutely right. Munir Bhatti's case would be relevant on merits will become. Yes, because there are
उन्होंने उसको इतना इतराज हुआ तो उन्होंने महमूद भट्टी केस के बावजूद जो है उसको मर्ज कर दिया पार्लियामेंट्री कमेटी में. उसमें जब ये बात हो रही थी कि जी उनकी भी कोई स्टे होनी चाहिए, हर दफा सुप्रीम कोर्ट उनका जजमेंट अंडू कर देता है. ये माजी की बातें हैं, ये सब जजमेंट में लिखी नहीं है.
2012 ये 11 की
इवन के एक जजमेंट हमारे पास था पिशावर हाई कोर्ट का, दैट वाज ऑथर्ड बाय मी एंड द 3-member bench was hearing this matter. Justice Munib, I and Justice Athar Minallah. That was dissented by Mr. Athar on this ground. Every member has a right to say.
अब आप एक क्वेश्चन और भी ध्यान ले लीजिए कि आप कहते हैं कि एग्जेक्टिव की तादाद बढ़ गई है, तो आप बार को किस पलड़े में डालते हैं, एग्जेक्टिव में या जुडिशरी के साथ?
इसमें नॉन जुडिशरी किधर हम पाएंगे ना, वो दे ओनली रिप्रेजेंट बार. देयर आर 3 फैक्टर्स.
लेकिन एग्जेक्टिव को तो नहीं करते ना.
ठीक, इसमें पहले तीनों थे. उसमें लॉ मिनिस्टर भी थे, अटॉर्नी जनरल भी थे, बार के नुमाइंदे भी थे, लेकिन मेजॉरिटी वाज रिटेन्ड बाय द सुप्रीम कोर्ट, बाय द जजेस.
बट देयर वाज a separate committee of the parliamentary
वो एक अलग थी.
अब वो मर्ज हो गया. अब बाहर के नुमाइंदे अगर तो काउंट करें तो शायद बैलेंस.
सर इसमें
ये तो उसके मेरिट्स की बात है.
इसके पीछे
आप जरा हिस्ट्री में जा रहे थोड़ा सा 18th अमेंडमेंट से पहले भी बता दें कि क्या सिस्टम हुआ करता था. 18 से पहले
तो सिर्फ यही होता था कि अपॉइंटमेंट ऑफ हाई कोर्ट जज वाज इन कंसल्टेशन विद द चीफ जस्टिस ऑफ दैट हाई कोर्ट एंड द चीफ जस्टिस ऑफ पाकिस्तान. उसको इंटरप्रेट किया हुआ है जजेस केस in 1996 and subsequently Asad Ali's case.
The primacy was given to the chief justice. Primacy was
under that judgment's primacy was given. At that time, it was entirely in the hands of the judiciary. Appointments had to be made. From there, under the 18th Amendment, a difference came about because they wanted bar should also be represented, and to some extent, the government may also be represented. This was the case which was before this honorable court, full court, under challenging the 18th Amendment. Under that challenge, there was also one of the comments. We were saying, now, after introduction of Article 175A, the majority is no longer, the judges are in majority, and therefore that is one where independence of the judiciary and separation powers have been affected. On that, a direction was issued, which is part PLD 2010 Supreme Court, in which that full court, consisting of 17 judges, had directed the Parliament to consider if 2 more judges of the Supreme Court should also be added to the Judicial Commission. Consequently, as a result of 19th Amendment, 2 judges, earlier it was only the Chief Justice and only the Chief Justice and 2 senior-most judges were part of the Judicial Commission. Now, 4 senior-most judges, along with 1 judge nominated by them, in overall, there were these 7 judges who which became part of the Judicial Commission, and majority
6 judges, 5 sitting judges and an ex.
There were 5 sitting judges, one retired judge. So now I'm coming to the appointment of the Supreme Court. When you come to the appointment of the High Court judges, naturally Chief Justice of that High and Senior Superior judges. In all cases, if we put, ultimately, when the case was decided of 18th Amendment in 2015, they said the direction of the Supreme Court, which was given in 2010, has been complied with by the Parliament under the 19th Amendment. Therefore, they think now the balance has been restored. That was what the judgment finally came out in 2015. So therefore, this particular history behind clearly shows that Supreme Court has always trying to guard the independence of judiciary and ensuring that in the matter of appointment of judges, they have the final say, meaning by a majority. What has been transformed adversely under the 26th Amendment, that majority is gone, which majority at one place was made part of the direction. No doubt at that time, when that direction was given in 2010, already the 18th Amendment had been passed. It could have been those learned judges could have said, what can we do? Now this is what the Parliament has done. But no, they said, we have to ensure, we have to guard against the independence of judiciary, against any violation of independence of judiciary. Therefore, we give a direction. And then we will see if they follow the direction, whether it was now in accordance with the basic structure or not. And they finally said it.
यहाँ पे एक सवाल पैदा होता है, डायरेक्शन किस बारे में दी? ऑलरेडी एक कॉन्स्टिट्यूशनल अमेंडमेंट हो चुकी है, उसको अमेंड किया गया, यानी उस अमेंडमेंट को मानते हुए दूसरे अमेंडमेंट के लिए डायरेक्शन दिया। हम सिंपल ये कह रहे हैं कि एक अमेंडमेंट हो चुकी है, क्या आप उसको मान रहे हैं या नहीं मान रहे हैं? असल बात इतनी है,
नहीं माने गई ना,
मानी गई
नहीं। जो डायरेक्शन दिया ना 2010 वाले जजमेंट में, मैं आपको
उस 18th अमेंडमेंट को फर्दर अमेंड किया गया था। इट वाज पार्ट ऑफ द कॉन्स्टिट्यूशन, इट वाज फर्दर अमेंडेड
and the court direction was given. Such a direction can even be given at this time also. There is a precedent.
सुन के देखेंगे
आप
amendment.
Yeah. And second committee has been constituted for the Constitution Bench. Even the committee of the Constitution Bench has been given protection under the 191A article.
No doubt.
In this article, the committee has been constituted. So,
No doubt
it is a
about it.
constitutional committee constituted under Article 191A presently.
That is why that committee initially decided that it should be a full court. We should first decide the validity of the 26th Amendment. Because this is where
the question for the constituting the full court, whether after 26th Amendment, the earlier committee constituted for the regular bench under the practice and procedure can decide the fixation of cases of the constitutional nature before the full court or not. This is the moot point which you have to argue and satisfy us on this point.
Certainly.
This is in fact the case.
Certainly, because that's where the conflict comes. You see, we are challenging the very basic structure.
Mr. Shahid in petition has
26th
also
Amendment.
he has raised the same question that the committee has decided to fix these cases
वो
before
लास्ट
the
में
full
लेंगे
court.
आपके पहले ये
नहीं वो आपका point वही है. This
जी,
is
जी,
in
बिल्कुल वही
fact
point.
the entire controversy is roaming around the जी ठीक है. That is why we are asking to
ऑब्जेक्शंस हैं आपके सुने
senior advocate to address on this point.
Yes, certainly, sir. Like to address. Because everything, you see, if for the time being, as it was a controversy when we filed these petitions before this honorable court against the basics, against the 26th Amendment, we do not want that article under 26th Amendment should be came into effect, because that would create the confusion which exists at this present time. It appears for the time being this honorable court has to consider that all that has passed between the 21st of October till today actually has ceased to exist, to see that we are virtually on the 26th or 27th of October 2024, because we are challenging that act of the parliament which took place at that point in time. So what is subsequently, some of the part had been come into effect, some have not come into effect. One of the reasons we have been repeatedly saying, making petitions, I have been filing petitions, one was dismissed in their special court cases, where I said that first please decide 26th Amendment cases, and then the rest of things should happen.
यही
That's what-
प्रॉब्लम यही है. अभी हम इस मौके पर इस स्टेज पर भी नहीं पहुंचे कि किसने सुनना है इसको. ये तो चलता रहेगा. पॉसिबल है अगले एक महीना हम इसी बात पर सुनते रहे. जैसे लॉयर्स पीछे भी 40 डेट ऑफ हियरिंग दी है, फुल स्ट्रेंथ पे सुना है. अब इस पॉइंट पर ही जब एग्री नहीं हो रहे कि किसने सुनना है, ये आप 10 दिन बहस करेंगे, वी आर हियर टू हियर यू.
जी सर.
तो इसलिए बाकी सारा काम रोक के तो वो नहीं, इस पॉइंट पर एग्री फर्स्ट डे होते आप कहते हैं ये आप सुन सकते हैं, आज भी आप कहिए कि ये आप नहीं सुन सकते,
तो डे वन से हम कह रहे हैं,
यही कह रहे हैं, लेकिन अंडर व्हाट प्रोविजन ऑफ द कॉन्स्टिट्यूशन?
सर देखिए ये
आप
जो
कहते हैं कि उसको इग्नोर करके 26 से पहले चले जाए, ये तो हमारे बस में तो नहीं है ये।
सर
I think the difference between substantive provisions and procedural provisions we have, which is something I noted in the dissent in the reserve seat case, nothing is barring a judicial order. Just to be clear, nothing bars a judicial order that a full court needs to hear the matter or a bench needs to hear the matter. The judicial order takes place, the process continues. After the order is made, then there is a process that implements the order. So the focus really, as I see it, again my question is that when you ask for a full court, where is the bar under the 26th Amendment to form a full court? And if where is the bar and who is to form that, and is that the request, the direction to form it, not something that is done in ordinary cases as well? So why not in this case?
No doubt, there is no bar. Let me give a...
In fact, at the instance of the bar, we often say there is a request for a larger bench, there is a request for a different bench, and we push the file forward. At that time, we don't question the process that will take place. We simply issue a directive that do it, and then the process takes place.
So there's a lot of precedent on that. I'll come to that.
आप प्लीज जरा
full courts were formed.
इसको एड्रेस कर दीजिए ना, इन इश्यूज को तो
हाँ, उसी पर मैं
अगर आप आर्टिकल
आस्किंग क्वेश्चन,
यहाँ तो
रिपीटेडली वी आर आस्किंग क्वेश्चन टू यू, प्लीज एड्रेस दिस पॉइंट, बताइए इसके ऊपर।
खान साहब एक मुश्किल आसान करते हैं, खान साहब एक मुश्किल आपकी आसान करते हैं। बेंच के मेंबर्स ने जितने सवाल पूछे हैं उसका क्रक्स लेने के लिए अकॉर्डिंग टू माई परसेप्शन आप खुद भी क्लियर नहीं है। जरा आप आइए सीएमए की प्रेयर क्लास पे आइए, सीएमए की प्रेयर क्लास जरा गौर से पढ़ें। आपने ये नहीं कहा कि ये बेंच एक ऑर्डर पास करे और ये बेंच लार्जर बेंच को कॉन्स्टिट्यूट करे। आप प्रेयर पढ़ें जरा प्लीज।
It is most respectfully and most humbly submitted that this honorable court may graciously refer this present petition as well as corrected petitions for the constitution of a bench consisting of full court,
बस यहाँ रुक जाएं।
which includes all.
आपने ये नहीं कहा कि ये बेंच किसको रेफर करे, किसको रेफर करे ये बेंच?
Naturally to the Chief Justice.
नहीं तो वो तो आपसे मैंने कहा ना, चीफ जस्टिस तो अब नहीं है मास्टर ऑफ रोस्टर, तो कमिटी है। एट द बेस्ट द मैटर विल बी रेफर्ड टू द कमिटी।
This is what I meant, that at that time the authority which could constitute full court उसके पास भेज दिया
बेटा
जाए।
दोनों चीजें अब अलग हो गई। एक तो रेगुलर बेंचेस की कमेटी है, द चीफ जस्टिस कैन नॉट कॉन्स्टिट्यूट द बेंचेस विदाउट प्लेसिंग इट बिफोर द कमिटी मेंबर्स बाय मेजॉरिटी ऑफ जो भी होगा। Similarly, the senior member of the constitutional bench cannot constitute any committee by his own, any bench by his own. He himself or he can't do this. He has to refer this matter to the committee. And again, the same committee for the constitutional bench will decide the constitution of benches for hearing of cases. So both committees are at par presently, one for the constitution and one for the regular.
दो कमेटीज है, किस में जाएगी? दो कमेटी, एक कॉन्स्टिट्यूशन के तहत कमेटी बनी है, एक एक्ट के तहत बनी है। तो आप ये भी हमें बताएं।
मेरी गुजारिश ये है कि वो कॉन्सिक्वेंस है 26th अमेंडमेंट का, विच इज अंडर चैलेंज बिफोर दिस ऑनरेबल कोर्ट। उस पर फिलहाल आप नहीं जा सकते।
एक बात जरा सुन लें, इससे पहले कई अमेंडमेंट्स कॉन्स्टिट्यूशन में थी या ओरिजिनल कॉन्स्टिट्यूशन था, जब तक वो कॉन्स्टिट्यूशन का हिस्सा था उस पर अमल होता रहा। मिसाल के तौर 52B हिस्सा था आइन का, बहुत से लोग इसको नहीं मानते थे लेकिन इंप्लीमेंट होता जा रहा था। जिस दिन वो खत्म हुआ उसके बाद इंप्लीमेंट नहीं हो रहा। सवाल ये नहीं है कि ये अमेंडमेंट अच्छे हैं या बुरे हैं, ये तो हम बाद में डिसाइड करेंगे कि ठीक है या नहीं है, कॉन्स्टिट्यूशनल है या अनकॉन्स्टिट्यूशनल। लेकिन जब तक ये खत्म नहीं हुए, ये तो इसमें मौजूद है। अगर आप आर्टिकल 191A3 पढ़ ले, देयर इज अ बार, आप पढ़ लें या फिर हमें बताएं, हम इससे कैसे देखें, आप हमें इससे निकाल लें।
हम तो कहते हैं 191A को फिलहाल आप नजरअंदाज करें क्योंकि ये तो प्रोडक्ट है 26th अमेंडमेंट।
कैन एनी प्रोविजन ऑफ द कॉन्स्टिट्यूशन बी मेड रिडंडेंट?
पहले ही
उसको रिडंडेंट कर सकते हैं, हम किसी प्रोविजन को रिडंडेंट कर सकते हैं।
Redundant कर सकते हैं। At the end of the day, you can
end of the day we can strike it down. We can, yes, of course. But so far it is part of the constitution.
ये हामिद
For the time being, it is under question.
ये बेंच जिसने बनाया था, द अथॉरिटी विच कॉन्स्टिट्यूटेड दिस बेंच, क्या उनके पास आपकी तरफ से कोई रिक्वेस्ट गई थी कि लार्जर बेंच बनाया जाए, एंड दैट एप्लीकेशन रिक्वेस्ट हैज बीन टर्न डाउन? कोई रीजंस दिए गए हों उसके?
देखिए, हम तो इसकी फॉर्मेशन को चैलेंज कर रहे हैं जी। हमारे नजदीक 191A के तहत जो इख्तियारात दिए गए हैं बेंचेस फॉर्मेशन के, दे आर कॉन्सिक्वेंस ऑफ 26th अमेंडमेंट. We think this amendment has virtually destroyed the independence of judiciary and separation of powers, and therefore we are not going into acts which are consequential of 26th amendment.
You're right, but during that process of challenging whether it is not in a field, it is in a field, 191A. So we cannot wriggle out of it, it is not, maybe you are challenging it and you don't accept this, this is what you are challenged before this court. But the fact remains, it is in the statute book or not, it is a part of constitution or not.
It is very much, unless this honorable court gives...
And if we pass any judicial order, perhaps, as you argued that this court can pass a judicial order, the judicial order should be within the jurisdiction or beyond jurisdiction. If we have jurisdiction under Article 191A to constitute the full court, please show us from the text of Article 191A. So this is the question of jurisdiction also. If we pass any judicial order, then we have to see what jurisdiction vested in it. Whether we can do this under Article 187.
Yes, under Article 187. Very much.
ये बताइए ना आप इसके ऊपर.
देखिए, बात ये है कि वो 26th अमेंडमेंट या उसके कॉन्सिक्वेंसेस तो हम चैलेंज कर रहे हैं, हम उसमें फिलहाल जाना नहीं चाहते.
We are not taking to there. We are asking for the bench only. We are not asking you to argue on the merits of the case.
We are only saying that on the judicial side, kindly consider this as important for saving the basic features that a full court should sit and decide. For example, the same situation arose back in 1997. When a judicial order was passed that the court should hear the cases under which challenge was made to the appointment of the then Chief Justice of Pakistan, and a bench was formed. Bench was directed to be made under Justice Siddiqui, who was head of that bench. The judge senior to Justice Siddiqui, or the senior puisne judge at that time, Justice Ajmal Mian, recused from there. But nobody questioned the judicial powers of a bench of the Supreme Court to direct formation of the full court. So that is a precedent. Otherwise, when this matter was before them, it was challenged even that Chief Justice has not formed this bench. How come you have formed the bench? The answer came that on the judicial side it could always be done. But if it has to be done on the administrative side, it has to be Chief Justice.
अगर इस तरह समझ लें, खान साहब, जुडिशल साइड आपकी बात मान लेते हैं, फर्ज करें, अगर आपकी बात मानते हुए हम ऑर्डर कर लेते हैं कि तमाम जजेस जितने भी सुप्रीम कोर्ट के हैं, दे शैल बी मेंबर ऑफ द कॉन्स्टिट्यूशनल बेंच, वुड यू बी सेटिस्फाइड?
मेंबर ऑफ द कॉन्स्टिट्यूशनल बेंच,
सारे तमाम जितने जजेस हैं सुप्रीम कोर्ट के, विल यू बी सेटिस्फाइड और नॉट?
नहीं, इसमें मेरी गुजारिश होगी, be satisfied if all 16 judges...
16 को ले लेते हैं, अगर हम ऑर्डर कर देते हैं कि ये 16 जजेस कॉन्स्टिट्यूशनल बेंच का हिस्सा बने, फिर आप सेटिस्फाई होंगे?
हिस्सा बना है कॉन्स्टिट्यूशनल बेंच का जो तस्वर है वो आपने 26वीं तरमीम के तहत दिया है.
हमने नहीं किया, पार्लियामेंट ने किया, हम पे ना डालें. पार्लियामेंट
उसी को तो हम चैलेंज कर रहे हैं.
ठीक है, हो सकता है आप सक्सीड कर जाए, हो सकता है आप सक्सीड कर जाए या ना कर जाए.
एक मिनट के लिए आप 191A को भूल जाइए, फॉर द रीजन दैट वो तो अंडर चैलेंज है ना सर. तो आप ये देखिए, हम वहां खड़े हैं जहां
अगर 191A को भूल जाएं तो फिर तो कॉन्स्टिट्यूशन बेंच का तस्वुर ही खत्म हो गया. बाय वी आर सिटिंग हियर,
कॉन्स्टिट्यूशन बेंच इंटरनल बेंच
खत्म हो गया उसका. देयर इज नो कॉन्स्टिट्यूशन बेंच.
खान साहब सुनिए, देन देयर इज नो सुप्रीम कोर्ट इन द कंट्री टुडे. There is no Supreme Court.
That's what we are saying. The Supreme Court is there.
नहीं है तो फिर
ये constitution
अगर आप 199 को अगर आप 191A को नहीं मानते हैं फिर तो ये बेंच खत्म हो गया।
बेंच क्या? सुप्रीम कोर्ट इन द कंट्री।
आप कह रहे हैं उसको हम भूल लेते हैं। चले हम भूल लेते हैं, आपकी बात मानते हैं, हम भूल जाते हैं, इसको एक साइड पे रख लेते हैं, फिर तो ये बेंच खत्म हो गया।
खत्म नहीं होता। It's still a bench of the Supreme Court.
This is the creation of Article 191A1 and A4.
Even today Supreme Court is under Article
फिर आपको
191A।
पार्लियामेंट को अप्रोच करना पड़ेगा कि एक फुल बेंच बना के ये
फिर कोर्ट बना है, पहले तो सुप्रीम कोर्ट
पे हाल पैदा हो सकती है, बट थिंग्स हैव टू बी रिजॉल्व जुडिशली, और इसको जुडिशली, वरना अगर हम इससे बाहर निकल गए तो फिर हमारी जुडिशरी बिकम्स टोटली मीनिंगलेस। तो हु विल सपोर्ट? बात यहाँ पर जो हम कर रहे हैं, ये 26th अमेंडमेंट इज एन अटैक ऑन द इंडिपेंडेंस ऑफ जुडिशरी। दैट्स व्हाट माय आर्गुमेंट। इसको प्रोटेक्ट करना, इस कोर्ट को और इसकी इंडिपेंडेंस को, ये सुप्रीम कोर्ट का अपना काम है, और इसलिए हमारी सबमिशन है, आप कॉन्स्टिट्यूशन बेंच नहीं, आप 8 मेंबर बेंच है इस ऑनरेबल कोर्ट का, और आपने हमारी सबमिशन को एक्सेप्ट करते हुए 16 मेंबर बेंच यानी फुल कोर्ट दैट एग्जिस्टेड द टाइम ऑफ पासिंग 26th अमेंडमेंट, उसका जुडिशियल ऑर्डर पास करना है।
इस बेंच को चीफ जस्टिस ने या जो प्रैक्टिस एंड प्रोसीजर कमेटी ने नहीं बनाया। ये बेंच उसके तहत बना ही नहीं है। तो अगर आप उसको नहीं मानते फिर तो इस बेंच का वजूद ही खत्म हो गया। फिर हम ऑर्डर कर ही नहीं सकते।
हम तो आपके सामने जुडिशियल ऑर्डर सीख रहे हैं।
देखिए ना,
ये बेंच नहीं कर सकेगा।
हम भी 191 को इग्नोर करें कि वो जुरिस्डिक्शन जो अंडर द कॉन्स्टिट्यूशन सिर्फ कॉन्स्टिट्यूशनल बेंच को है, हम बाकी जजेस को मतलब कॉन्फर करें बाय ऑर्डर ऑफ दिस कोर्ट to hear these petitions.
तो 191A जो है वो तो फिर infructuous हो गया ना, it has become redundant, and before hearing you it amounts to making it redundant unless you argue the whole case at the relevant time, and we will reach to the conclusion whether it is against the basic structure or what are the defects in the amendment. That would be a different story. But right now you know that you are very senior counsel. Article 5 of the Constitution, loyalty to the state is the basic duty of every citizen. Obedience to the Constitution and law is the inviolable obligation of every citizen wherever he may be, and of every other person for the time being within Pakistan.
Yes.
So 191A is a part of Constitution presently, unless it is treated otherwise or struck down at the final stage of the case. But right now it is the part of the Constitution. And you say that ignore it and make the full court. How within that jurisdiction we can do this? I am asking this for last many
सर, मेरी गुजारिश ये है कि मैं बारहा अर्ज ही कर रहा हूँ कि आपको 1 मिनट के लिए ये तस्वर करना पड़ेगा कि आज कल 26वीं तरमीम पास हुई, अब इस पर कोई एक्ट ऑन नहीं हुआ। तो अब देखना ये है कि ये जो 26वीं तरमीम है, क्या ये आइन के बेसिक स्ट्रक्चर के मुताबिक है कि नहीं?
That will be seen at the relevant time when you will argue the case on merit.
इसलिए
right now this is question of bench. You are asking us to do something which can be do under the Constitution. Please satisfy on this point.
सर, वो हम उस पर सेकंड स्टेज पे आएंगे। मैंने पहले ही कहा, ये जो कुछ भी मैं सबमिट कर रहा हूँ ये फुल कोर्ट फॉर्मेशन के हवाले से है, क्योंकि इम्पोर्टेंस ऑफ द सब्जेक्ट बिफोर योर लॉर्डशिप इज सच इम्पोर्टेंट वन दैट ओनली हाफ ऑफ दैट फुल कोर्ट is at present before us. We are only seeking that please also include the other learned 8 judges who were judges of this honorable court at the time when 26th amendment was passed. This is nutshell of my submission. और इसके लिए I am trying to take precedent. आपके पाकिस्तान के प्रेसिडेंट क्या है
बताइए।
मैं आपको ब्रीफली सारे प्रेसिडेंट बता देता हूं, जिनमें हमेशा फुल कोर्ट बनी है। जहां भी इंपॉर्टेंट कॉन्स्टिट्यूशनल क्वेश्चंस अराइज हुए हैं वहां पर फुल कोर्ट बनी है। ये तकरीबन 70 साल की बात है। अब देखिए, पहला जो इस किस्म का केस है वो आप सब जानते हैं, फेडरेशन ऑफ पाकिस्तान वर्सेस तमीजुद्दीन खान, PLD 1955 Federal Code 240. It was consisting of full court, At that time, Supreme Court's sanction strength was 5 judges. One incident I'll just point out for the sake of history. One of the learned judges was, however, not available. Justice Shahabuddin. He had been given an assignment as additional governor of East Pakistan. In his place, they completed the quorum of 5, the strength of 5, by taking an ad hoc judge. At that time, the Chief Justice of Lahore High Court, Justice S.A. Rahman. So again, full 5-member bench decided this case. Then, sir, next case which I'll be referring to, I'll give the list also tomorrow.
Yes, yes.
Jubindra Kishore versus Province of East Pakistan. This was relating to the Viaries of East Pakistan State Acquisition Tenancy Act. A very important
Citation.
constitutional question.
Citation क्या है इसकी?
Citation, sir, PLD 1957, Supreme Court 9. By that time, the 56th Constitution had come into existence. It was again full court.
What is the third case?
The third case, State versus Doso. PLD 1958, Supreme Court 533.
553.
533. This 533. At this time, there were only 4 judges of the Supreme Court. One of the judges' vacancy was there. So this was a case heard by 4-member bench. Full court for all intents and purposes. That was the available judges of the Supreme Court. Then next, very important case, again, question of interpreting the Constitution, was Fazlul Qadir Chaudhary versus Abdul Haq. PLD 1963. PLD 1963, Supreme Court 486. In this case, a statute was struck down because it was against the Constitution, and at that time it was provided under the Constitution that a minister cannot be a member of the Parliament in a presidential system. But in the garb of resolving the difficulties, the provision of the 62 Constitution, they allowed the ministers to retain their membership of the Parliament. This was struck down by the Supreme Court, by a full court, at that time 5-member Supreme Court. Then, sir, next important case in this regard is Maulana Maududi versus Government of West Pakistan. PLD 1964, Supreme Court 673, in which Supreme Court set aside the notification by the government declaring Jamaat Islami as unlawful association. Again, a case, constitutional case of national importance. Then, sir, next case I'll be referring, Province of East Pakistan versus Sirajul Haq Patwari. PLD 66, Supreme Court 854. Again, all 5-member bench decided relating to the election of certain functionaries under the basic democracies model. So therefore, again a full court. Yes, our next important case is Asma Jalani versus Government of Punjab. PLD 1972, Supreme Court 139.
एक मिनट रिपीट कर दीजिए प्लीज.
जी सर.
रिपीट कर दीजिए PLD.
Yes, 1972, Supreme Court 139.
ये आसमा जिलानी होगी ना.
This was where the martial law and the consequential acts which were performed by General Yahya Khan was declared as illegal, unconstitutional and invalid. The 5-member court and all 5 judges sat there. The next important case is the State versus Ziaur Rahman. PLD 1973, Supreme Court 49. Again, 5-member bench, all 5 sat to decide this case. Then next, Begum Nusrat Bhutto versus Chief of Army Staff. PLD 1977, Supreme Court 657. Sir, at that time, the strength of the court was 9 judges, including the Chief Justice. All 9 of them heard and decided this case. And next case is Federation of Pakistan versus Haji Muhammad Saifullah Khan. PLD 1989, Supreme Court 166. At that time, the strength of the Supreme Court was 12 judges, including the Chief Justice. They all heard this case together, and in which it was decided, upheld the judgment of the Lahore High Court, but did not allow the election to take place, allowed the election to take place and did not restore the government of Mr. Junejo. Then, sir, next important case in this regard is about the dissolution of the assembly headed by Benazir Bhutto Sahaba. It is Khwaja Ahmad Tariq Rahim versus Federation of Pakistan. PLD 1992, Supreme Court 646. At that time, the strength of the Supreme Court was 12 judges, and all 12 heard this case. Then, sir, next case is Muhammad Nawaz Sharif versus Federation of Pakistan. PLD 1993, Supreme Court 473. At that time, the full court consisted of, or available judges were 11 judges. This decision was taken by all 11 members of the court at that time. Then, sir, this 90s precedent. Then, sir, Malik Asad Ali's case. Malik Asad Ali versus Federation of Pakistan. PLD 1998, Supreme Court 161. In my humble submission, this is one of the most relevant cases in the context of Pakistan, because there the question was what should that whether the appointment of then Chief Justice was valid or not, and therefore all the judges available, those, because at that time there were 5 or 6 other judges, Chief Justice did not become part of, or was not made part of this bench, and so Justice Ajmal Mia also recused from there. So these 10 judges were the available judges and formed a full court, and that's what they explained. Because they even explained in this judgment that 7 judges could not sit on the bench and had recused, and therefore only 10 members are available as full court. Then next case, Chief Justice Iftikhar Muhammad Chaudhry versus President of Pakistan. PLD 2010, Supreme Court 61. Now this was decided by 13-member, but a full court. Others had recused. Actually, the Chief Justice's case, so he could not sit, and so were some other judges not available. So the available judges were 13 judges. It was formed a full court, and the case was decided by this full court consisting of 13 members. Then, sir, next important case was Bashar Hassan versus फेडरेशन ऑफ पाकिस्तान, इसमें सिंध हाई कोर्ट बार एसोसिएशन का केस है
सर है
कहाँ पर है तो Sir, sorry, next case which I like to refer to is Sindh High Court Bar Association versus Federation of Pakistan.
Petition बताए.
Sindh High Court Bar Association versus Federation of Pakistan. PLD 2009 Supreme Court 879 decided by full court of 14 judges. At that time, this may kindly be taken as precedent, there were about 15 other judges who had been appointed under provisional constitutional order. So the question was whether they could form part of the bench, full court or not. So the answer was that since the very provisional constitutional order was under challenge and those appointed under that, they could not sit under it, and therefore only 14 judges who had not taken oath under PCO were available and was considered as full court and decided the matter. Then sir, next, Mubashir Hassan versus Federation of Pakistan. PLD 2010, Supreme Court 265. This was decided by all 17-member full court, where the vires of National Reconciliation Ordinance 2007 was struck down, was under question and was struck down. Then sir, next very important case was Nadeem Ahmed versus Federation of Pakistan. In this case, insertion of Article 175A was challenged, and therefore the bench which was formed was of full court. All 17 judges, Chief Justice and all 16 judges sat in this case, where the vires of certain provisions of the 18th Amendment was there. And in that case, what happened was that matter was partly decided and partly sent to the Parliament for adding 2 more judges to the Supreme Court under the Article 175A, and it was done under the 13th Amendment, 19th Amendment.
Citation
and therefore
citation is
citation is PLD 2010, Supreme Court 1165. The next, again, very important case is that of District Bar Association Rawalpindi versus Federation of Pakistan. PLD 2015, Supreme Court 401. In this case, vires of 18th and 21st constitutional amendments were challenged, and the 17-member by the full court sat on that and ultimately decided the petition against the objection, because it said that since by amendment, 19th Amendment, they have already added 2 judges under Article 175A, therefore that matter is rest. So now this is not a question of judicial independence. So therefore that was allowed. And the other matter in this was that of military courts for 2 years, introduced under 21st Amendment, in which by 11-6 our petition was dismissed. But one thing very remarkable about is that actually the judgment, which is the main judgment on merits, I will be relying on that judgment, because there at least 14 judges out of 17 agreed that these are the basic features of the Constitution.
Salient features. Salient features.
जी?
Salient features की बात की गई.
salient features.
salient features.
वेरिएंट फीचर की बात की मगर वो अमेंडमेंट को अप्रूव कर दिया प्लूरिटी जजमेंट के अंदर भी और वैसे भी
वो कर दिया, लेकिन उसमें जहाँ तक defining the basic features of the constitution, उस पर 14 judges were,
which includes independence of judiciary as well.
Independence of judiciary and separation of powers, the democratic system, all that. That was at least by 14 judges.
के अगेंस्ट तो होल्ड तो नहीं किया उसको उन्होंने
जी,
बेसिक फीचर के अगेंस्ट होल्ड तो नहीं किया उस 17 जजेस ने
किया, मैं समझता हूँ किया। उसकी वजह यह है कि उसमें तकरीबन जो 6 डिसेंटिंग जजेस थे जो उन्होंने हमारे हक में फैसला किया था, उसमें 5 जजेस ने तो क्लियरली ये कहा है। एक जज ने वेंट इनटू ऑल टुगेदर डिफरेंट टेंजेंट, जस्टिस खोसा, सो दे डिड नॉट कंसिडर दैट, बट आउट ऑफ दोज सो कॉल्ड majority, 8 judges agreed with that there is basic features of the constitution and anything against it can be struck down. They made an exception of 21st Amendment by saying that since it has a sunset clause, that is, the military courts were allowed only for 2 years.
And again
therefore,
2 years.
They said we are ready to condone it. Otherwise, substantively they said that it should be struck down. Then, sir, next very important case in this regard is
ये जो salient feature की बात हुई थी 17 judges ने, now it will be considered a judgment of 17 members.
this is 17 by
salient feature की बात उसमें हुई थी
जी, उसमें सर
अगर
14
जो मैं कहने वाला हूँ कुछ और
जी,
अगर कोई उससे छोटा बेंच होगा तो उन salient feature को चेंज कर सकेंगे या नहीं कर सकेंगे? जो बात 17 ने कही है, क्या वो 13 या 15 या 16 कर सकेंगे, यानी उसके अगेंस्ट जा सकेंगे या नहीं जा सकेंगे?
मैं नहीं समझता जा
और अगर उससे ज्यादा हो तो जा सके, 17 से अगर ज्यादा हो तो
देयर हैज टू बी, ये 17 से ज्यादा, क्योंकि बेशक 14 ने ये बात कही है लेकिन वो जजमेंट तो
17 की, वो 17 की तस्वीर
नीड मोर देन 17 टू डू
क्या आप खुश नहीं होंगे कि वो बरकरार रहे और 17 से छोटा बेंच हो?
So next judgment I'll be relying on is Justice Qazi Faiz Saab versus President of Pakistan. This is PLD 2021 Supreme Court 1. In this case, there were objections on some of the learned judges. So therefore, the full court was agreed upon. They agreed that there should be full court. Court of 10 judges, because rest of them had either recused themselves, so therefore only these 10 judges were the available full court. They sat and decided this. Similarly, afterward then its review petition was heard by again the 10-member bench. This is Justice Qazi Faiz versus President of Pakistan, PLD 2022 Supreme Court 199, in which
दोबारा बताएगा
जी सर,
PLD
199
PLD Supreme Court
and sir
199 साल के
sir, about reconstitution there is another judgment.
बेहतर होता हामिद साहब आप हमें ये लिस्ट प्रोवाइड कर देते हम
वैसे by tomorrow I'll have this list provided here. जी सर, इसमें एक स्टेज पर ये हुआ था, कॉन्स्टिट्यूशनल बेंच का प्रॉब्लम मामला आया था, क्योंकि 6 जजेस के सामने रिव्यू पिटिशन लगी थी and we objected to that it has to be heard by 10 judges, a bench of 10 judges at least. In that case, it was decided, yes, the same number of judges will hear the review petition and the same judges. But in the meantime, one of the learned judges who formed the majority in that case, Justice Faisal Arab, I think he had retired, and in his place, Justice Amiruddin Khan was made a member of that bench. So therefore, that was for all intents and purposes a full court that heard. Then Raja Amir versus Federation of Pakistan.
बता दें पूरे कितने और बाकी हैं, 2
Raja Amir versus Federation of Pakistan. The Supreme Court Practice and Procedure Act was.
इसका साइटेशन बता दीजिए।
I'm just going to conclude. 1 or 2 and
राजा आमिर का साइटेशन बता दीजिए।
जी सर, इसकी साइटेशन है PNJ है
PNJ में रिपोर्ट हुआ है।
PNJ 2024 Supreme Court 114. So what I'll say, very correctly pointed out by the lady Justice, that formation of full court for hearing important constitutional cases is a matter of precedent and convention in Pakistan. If your Lordship kindly see the record of the last 60 years, 70 years from 1955 to 2025, all important constitutional cases, including the cases pertaining to the constitutional amendment, have been heard by the full court.
Sir, don't you think all these reference cases are distinguishable? Because during all these decisions, there was no Practice and Procedure Act, nor there was any 26th Amendment. And second, are we all bound by the law and the Constitution or not?
Sir, the difference is that in these cases, whether the Practice and Procedure Act had come or not come, there was an authority who could form a bench, full court. So therefore, it didn't matter who had the authority. The fact remains, the bottom line is that full court heard that case.
In all these cases, Chief Justice was the authority. And he constituted the bench on administrative side, and on judicial side, all the sitting judges heard the matter. But now we are having some constraints. CJP is there, but the constitution bench is also there. There are 2 committees dealing with the affairs of fixation of the matters.
Sir,
We are again at point 0.
I follow what your Lordship said.
Moving around a roundabout. You're not leading us to any path.
Sir, what I am submitting here, that whoever may have the authority, but the bottom line is all cases of this importance are heard by full court.
Third question, whether any application was filed before the committee of the Constitution bench to fix the matter before a larger bench or the full court of the Constitution bench?
We are challenging the very formation of that committee.
I don't think so.
Because we think that Article 191A is ultra vires the Constitution.
Kazam, you've concluded on this application?
हमें सब एक मेरा ख्याल है एक मैं जो समझ रही हूँ अभी तक, and that is कि आपके ख्याल में फुल कोर्ट इसलिए भी जरूरी है कि जो अमेंडमेंट्स हो चुके हैं अकॉर्डिंग टू यू, वो जो सेलियंट फीचर्स है कॉन्स्टिट्यूशन के उसी वो नहीं रहे अभी अपनी जगह पर बहुत सारे. तो यू मीन कि वो कॉन्स्टिट्यूशन फुल कोर्ट की हो जाए so that the matter is decided once for all.
Once for all, by consensus of this court.
By consensus of this court. Bypassing the ये जो amendments हुई है या practice and procedural act जो है, क्योंकि एक नई चीज इंट्रोड्यूस हुई है जिसने जुडिशरी की फेस को चेंज कर दिया है under the 26th amendment. क्योंकि पार्लियामेंट का एक्ट उसमें ज्यादा बढ़ गया है.
बेसिकली बात मैंने अर्ज की थी कि यहाँ पर क्वेश्चन है कि जुडिशरी इज अंडर अटैक अंडर द 26th अमेंडमेंट, सो इट इज द फुल कोर्ट वुड बी अप्रोप्रिएट दैट फुल कोर्ट sits and hear this case because then the duty of the court is to save its independence. Because not only here, Article 2A is also saying so is our preamble.
Has argued
Conclude कर लिया ना आपने?
and concluded his arguments on application for constitution of 16 members bench. For arguments of other counsel, adjourn for tomorrow 11:30.